Good afternoon, everyone, and welcome to our GDPR 2-year on panel discussion. For those of you who've joined us on one of our GDPR webinars before, you'll notice this is taking a slightly different approach. Rather than a presentation for an hour long, we have a panel discussion for today's webinar. So, as a way of introduction, your panellists today are, we have Joanne Bowe, who is a partner in our commercial team and specialises in data protection. We have Padna Tardy, who is a senior associate in our employment team, and we have Neil Bentley. So Neil is head of legal for regulatory matters at TransUnion, which is one of the UK's largest credit reference agencies. And Neil and his team concentrate on data protection and FCA issues. And you have myself, Lauren Burrows, who's an associate in the commercial team dealing with data protection as well. In terms of the format for today's webinar, you'll see that there is a Q&A slide on the side of your screen, hopefully, or you'll be able to bring up the Q&A slide. So if you want to ask questions throughout, then we'll try and answer those as we're going through, and hopefully towards the end we'll also have some time for questions as well, which we will go through. Just before we make a start, just to assure you all we don't have a gogglebox situation, Joanne and Neil are married, so we are still adhering to the social distancing rules from the government. So without further ado, our first discussion today is something that I'm sure a lot of you will have been looking at recently, and that is in relation to the Morrisons case. As a quick update in relation to the facts, this related to 100,000 Morrison employees' payroll data. There was an aggrieved employee who'd been through a disciplinary process. He wasn't happy about that, so as part of his role of getting those payroll data to send to the external auditor, he'd actually saved that payroll data and made it available on the dark web. He then contacted a lot of different newspapers to let them know that that data was up there in a public forum. Whilst doing this, he'd also tried to frame one of his colleagues, so a colleague that had been involved in that disciplinary procedure. He actually set up a email account in his name, and he tried to frame him for it. So Morrisons became aware when they were contacted by one of the newspapers, and they immediately took steps to make sure that that data was taken down. They also paid a significant amount of money to protect those individuals whose personal data had been leaked. So that's a quick roundup of the facts. Joanne, what did the court say about this?
Well, I think the first thing to say is to put it into context is that when Morrisons told the ICO didn't take action against Morrisons. So I think that sort of sets the context. Then it got to the courts, obviously, because of the group action that was brought by the employees. So we saw it in terms of going through the High Court, the Court of Appeal, and then ultimately recently we've had the Supreme Court decision. The Court of Appeal initially said that they thought that whilst Morrisons were not directly responsible for the breach, they would be vicariously liable for what their staff member had done. And vicarious liability essentially is that while you don't think that the employer is directly liable, they become liable as a result of the actions of the employee. The Supreme Court took a different view, and I think it's interesting in terms of what they said about vicarious liability and where the faults lay. They took the view that Morrisons weren't directly responsible, and nor were they vicariously liable for what happened in the particular situation. What they basically said is, in order for there to be vicarious liability, what the employee has done has to be so closely connected with the acts that they're authorised to do that they should be properly regarded as being done by their employer. So when you think about the facts of this case, which are very odd to say the least, on the basis that the employee was essentially engaging in his own personal vendetta and deliberately put them on the dark web to further that vendetta rather than to do anything for his employer, and also was trying to frame a colleague, the court decided that what you couldn't say that what he was doing was so closely connected that Morrison should be responsible for what he had done. I do think it's quite fact-driven, this, and I think anybody that is looking at the Morrisons case, I think, needs to have a look at the particular facts. And from a vicarious liability point of view, I think there will always be quite fact-driven. Padma, obviously you're an employment lawyer. Is this decision consistent with what's gone before from a vicarious liability point of view? And do you agree that a lot of things will be driven by the particular facts of the case in terms of what a particular employee has done?
Yeah, I completely agree. I think when the decision first came out at a lower level, where it was held that Morrisons were vicariously liable at that stage, it was quite a concerning decision for a lot of employers. And I think typically where we look at vicarious liability tends to be discrimination in employment cases. And again, it's this whole thing of done during the course of conduct of employment, close connection, and so on. So I think it is quite consistent. So I think it's the decision is good news for employers, very fact sensitive, as you say, but I think it does at least put an end to that paradoxical situation where otherwise courts in certain circumstances were effectively furthering the malicious aims of an employee.
We've had, in terms of what Morrisons had done and the courts, do you think that the courts felt that Morrisons had done as much as they could do, and would the decision have been different if the information if Morrisons hadn't been contacted by the newspaper and more people have essentially seen those records? We've had that's two questions that we've had through from the Q&A. I think from my perspective, obviously, when it may have affected maybe the ICO's approach in terms of what they may have fined for because of the risk then to the individuals, but obviously Morrisons had spent millions of pounds to try and protect that. So again, I think it would depend on what the consequences had actually been in those circumstances. I don't know if you have anything to add, Joanne.
Yeah, I mean, I think it's interesting. I don't think it would have affected the Supreme Court's decision about vicarious liability, whether the data was published or it wasn't published, because I think it looks at the actions of the employee, and whether the data was made available or wasn't made available, I don't think would change whether or not you would regard what he'd done as so closely connected with what he was meant to be doing. I think what I would say is clearly the ICO thought that Morrisons had done what they should have done, otherwise they would have potentially taken action, and I'm not sure it would have changed whether it was published or not published in terms of whether they had taken appropriate security measures. It might have changed the ICO's advice in terms of notifying individuals, but clearly the individuals were told anyway. So I'm not sure that it would have changed things massively, to be honest.
And do you think, Joanne, that going forward, employers won't be responsible for a data breach if an employee does something wrong in a similar way?
I think one of the things that's really interesting on the Morrisons case is one of the things that was considered is there a statutory bar for claiming vicarious liability in relation to data protection issues. And the court said that you definitely still could claim vicarious liability if it were a situation where vicarious liability would arise. They considered the Data Protection Act 1998, but I think it would be hard to say that it wouldn't apply equally to GDPR. So my view is that it would apply equally, and that essentially there can be vicarious liability for data breach issues. I think one of the things that people need to be quite wary of, and whilst it is a helpful decision, is that it's not a free pass for people to decide that they're not responsible for data breaches just because they've got an employee involved. And so, yeah, I think people have to be very careful in relation to data breaches in the same way that they would have done before.
So, Neil, from your perspective, from businesses, this is seen as a positive outcome. So what can businesses do to help show that a staff member is outside the scope of their employment?
So Lauren, I think this is good news for business, the Supreme Court decision here. I think to say if they were to have said that to be liable for, you know, if a staff member goes off on a frolic of their own, no matter what, that the business is going to be liable, would have been the wrong thing. So it is good. I think it's important that businesses just go through the normal steps that they should be going through with their staff, and so for instance that they're doing GDPR training, they're doing regular refreshes of that training, that they're keeping training records as to what training their staff have gone through, so that in the event that a breach does happen and the ICO were to ask them, then there'd be evidence there. Obviously, that ties into making sure that the business has its appropriate policies. I think also data minimization is also key as well here, making sure that staff have only got access to the data that they need in order to do their job. So there's still lots of things that the businesses need to ensure they do.
I think one of the other things that I'd add to that as well is making sure that you've got the right people doing the right things and that you've carried out appropriate due diligence in relation to your employees. In terms of if you've got people handling very sensitive and important material, then you need to think about what due diligence you might do in relation to those and make sure that they're the right people to be doing that job.
Okay, thank you. So the next slide that we have, and the next topic of conversation we have in relation to two other cases that some of you may have been looking at this past year. So the first one is in relation to Lloyd and Google. So Mr. Lloyd launched a representative action against Google for Google's use of a technical workaround to bypass the cookie settings on the Safari browser, which placed tracking cookies without the individual's knowledge or consent, and then collected, used and sold the data. So Mr. Lloyd's representative action was an opt-out litigation, which is different to that we saw in Morrisons' case. So this meant that he was able to claim on behalf of more than 4 million affected individuals in England and Wales. Neil, where do we stand with the courts in relation to this, and do you think that this will open the floodgates going forward?
There's significant concern around this case from the point of view of potentially opening the floodgates to claims. And particularly sort of a new form of representative action that's being considered here. I think many data businesses in particular will be very pleased that this is now going to appeal, and that it's going to have further consideration from the courts. And I think there's some key issues here going to the heart of GDPR around the expectations there are around greater transparency, both to consumers and to regulators, things like personal data breach reporting, and how that would fit with these much wider rights that consumers and claimants would have if Lloyd and Google wasn't challenged.
And the further case we have was in relation to Atkinson's and Equifax. So Equifax suffered a major data breach which compromised its systems back in 2017. This affected 143 million individuals, which included 15 million UK customers. So Equifax were fined both in the US under a lawsuit and by the ICO in the UK. The ICO had issued a fine of 500,000, which, as it was a pre-GDPR fine, was the maximum they could fine at that point. Neil, what's your perspective in relation to this? What do you think of the Atkinsons versus Equifax case?
I think in terms of how that's proceeded since, from the point of view of the case now being dropped and the claimant, as I understand it, paying the Equifax's costs here, suggests that claimants are going to think twice before using the Lloyd and Google arguments, before Lloyd and Google is fully decided in the courts. I think there's it is useful to put a brake on that while Lloyd and Google is still being considered. So we'll I think many businesses will continue to watch that with interest.
And Joanne, in relation to these two cases, how do you think this is affecting things in practice?
Well, certainly we are seeing Lloyd and Google trotted out quite a lot in terms of if somebody thinks that there has been a data breach or a breach of GDPR, then quite often, in addition to the points that they're making, they're sort of wanting damages pursuant to Lloyd and Google. And certainly we are aware that some people will even take detailed legal advice and a barrister's opinion and try and recover the costs of those as part and parcel of the complaint that they're making in relation to the data breach or what they perceive as being a mishandling of their data. I think, as Neil says, it's one of those things that people have latched onto when it's not actually being decided in terms of where we are with liability on Lloyd and Google. From my personal point of view, I think Lloyd and Google, even if the court does decide that damages are to be awarded, I think it is quite fact driven. I don't think, and I could end up regretting saying this, but I don't think that the courts want to open the floodgates that every time there's a data breach that there can be a representative action for everybody to bring a claim in relation to where there's not been substantial losses or anything of that nature. So I do think it might well turn on its facts, and certainly I hope it turns on its facts if liability is established. And as I say, as Neil said, we still don't know whether or not the courts are going to say that damages are payable in this situation.
Yeah, I think one thing I've seen quite a lot as well is people pushing back in relation to DPAs and contracts in terms of using this as a liability stance of where they want to push on who's going to be responsible for this liability as well.
Yeah, it's one of those cases. I think it's interesting that, notwithstanding the fact it's not really being decided in terms of on the main issues, that it does get touted around quite a lot.
Yeah. So moving on from those main cases that we've seen in this past year, something that obviously when we'd initially started to prepare for this webinar, we'd taken a different approach of what we've actually ended up with now. Obviously the hot topic at the moment, and something which I'm sure is on everyone's minds, is in relation to COVID-19 and data protection. We've had quite a lot of questions in relation to this before the webinar, so hopefully we can have a discussion which will answer some of those questions now. So we have previously done a webinar in relation to cyber security issues, which covered from both an employment and data protection perspective, dealing with working from home, printing from home, how are you ensuring that your employees are still adhering to any policies or acceptable use. So that was done last month. If you would like a recording of that, then please let us know. There'll be an email at the end of this webinar. So because we've done that, for the purposes of this webinar, we're going to deal more with the data protection issues and practically, rather than looking at cybersecurity. But like I say, if you'd like access to that cybersecurity webinar, then please let us know after this discussion. So Joanne, from an ICO's perspective, what I'm seeing a lot and getting asked questions a lot is the ICO, have they just relaxed everything and you don't need to worry about GDPR at the moment? So what's their position in relation to COVID?
Well, certainly that is not true. They haven't given up on GDPR because of COVID. I think there are, they have got a data protection and COVID hub on their website, which, like everything else to do with COVID, is fast moving, and if you checked it a week ago, you'll probably find there's new stuff on it on a regular basis as the situation evolves. I think they're looking at things from 2 points of view. The first is from how they regulate, and the second is about what help they can give to people. And I think a lot of the misconceptions surrounding COVID means that nobody has to do anything from a data protection point of view come from a statement that they gave in relation to how they're going to regulate. And what they have said is that they do recognise that there's both a resource issue and an economic issue arising from COVID for a lot of businesses. And so they want to take what they call an empathetic and pragmatic approach. What they are not doing, though, is saying that you don't have to comply with a subject access request and you don't have to deal with data breach issues. They have expressly said that both of those things do need to be dealt with in the ordinary course of things, and you should, unless you have got a problem arising as a result of COVID, which you can substantiate to the ICO, meet the standard deadlines, so that if you've got a data breach, you still should be reporting within the 72 hours, and you've still got the calendar month in relation to subject access requests. We're certainly seeing a lot of people who think that from a subject access point of view, you just write back to people and go, COVID, not going to bother responding until all this is done. And that's certainly not what the ICO is saying. What they are saying is that if you have, for example, got a problem in terms of resourcing, so if you've got a lot of staff that are furloughed or you can't access some of the records that you need to be able to respond to a subject access request, then they might give you a bit of leeway in terms of not taking action against you if you've not been able to reply in full to the subject access request. One of the things that I would say, though, is that if you are affected by COVID in relation to this, I think, one, you need to explain to people how you're affected rather than just going, COVID, not therefore responding. I think you need to keep records internally as to what your challenges are, so that if the ICO looks into this. And I think the other thing that you do need to do is provide what you can. Certainly whenever we've been sort of arguing with the ICO, or maybe arguing is not quite the right word, but whenever we've been considering that on a subject access request there should be an extension because the request is complex, one of the things that the ICO is very keen on is that you provide what you can and then the complex information follows. And I think you can draw an analogy with COVID, so that if, for example, you can easily access, say, a personnel file, if it's an employee subject access request, you send that, and then the things that maybe you are struggling to provide because you've not got access to systems or paper records or anything of that nature, then you explain that that will follow. So very much, I don't think it's a case of you don't have to comply with those sort of things due to COVID. And for anybody that's seen the news today, you'll have seen that obviously there has been a data breach which EasyJet have reported, and so clearly things are still happening and still are being reported from that point of view. The other thing that the ICO is trying to do is to be helpful in relation to things, so to try and give advice in respect to things. So, for example, one of the things that they're looking at is that they're looking at the data protection impact assessment, so the risk assessment in relation to the NHS app that's currently being trialled on the Isle of Wight. So whilst I think the view is by the developers that it doesn't give rise to issues which they can't mitigate, they did want to work hand in hand with the ICO in terms of whether or not it was protecting privacy appropriately. So that is one of the things they're doing. One of the other things that they're doing from a sort of advice point of view, which is quite helpful for employers, is looking at things like what do you have to do in relation to employees. So, obviously most of us are unable to go back to work, although obviously some people have gone back in the last week or so. But when people are going back in, can we do what's happening in China, which is, can you stand there with a sort of scanner and take people's temperature and things like that? And equally, should you name people within a team who have got COVID to enable people to protect themselves? And they're sort of offering advice in relation to those things. In relation to the point about taking somebody's temperature, what they've said is that they consider that to be surveillance. So in the same way that they consider surveillance in terms of if you're looking at what emails people have been sending, or websites that people have been looking at, or CCTV, taking somebody's temperature is regarded as surveillance in the same way. And so what you need to do is you need to think about the things that you would think about in relation to those things. They're seen as quite privacy intrusive, and I think they consider that taking somebody's temperature is also quite intrusive, and also it's got the sort of added issue that when you're taking somebody's temperature, rather than potentially whether they're sending emails they shouldn't be sending, is that it includes special category data because it potentially involves the disclosure of health data. So what they're saying is you should be, for example, you should be thinking, well, is there a less intrusive way of doing this? Can I get people back to work in the premises without taking their temperature when they come through the door. You need to do a data protection impact assessment, which, as I say, is a risk assessment document, because it is something that will be seen as high risk. You need to be transparent with people, so people need to understand why are you taking their temperature and what are you going to do with the information that you get out of it. And also, you know, when will it be disposed of, which I think is something that a lot of people will be interested in. And also making sure that you've got the right legal basis for doing what you're doing. So because you've got special category data, you're going to have to be able to show that, one, you know, you've got an Article 6 condition which allows you to do it, but also that you're allowed to do it under Article 9. So it is something, I think what the message they're trying to give is that you shouldn't have somebody stood there automatically without thinking through the privacy issues with a thermometer sort of scanning people as they come through the door. And certainly, again, from a privacy point of view, naming people within the team who have got COVID is not something, again, that they feel you should be doing unless you don't really have any choice. I do think it raises an interesting issue, and I'd be interested in Padman's views on it, in terms of, obviously, employers have got more than, you know, just the people that they're sort of the individuals that potentially have got COVID or that they're scanning them through the door. They've got responsibilities to other employees. Padman, what's your view in terms of how they balance the two issues?
Yeah, I agree with you on that. It's quite a tricky thing, and again, another thing is quite fact sensitive, depending upon the industry that you're in, and what your obligations are, what you have around you, and whether people can work at home or not. We've obviously recently seen the new HSE guidance that's come out, with the government saying these are the steps that you need to take. You need to do risk assessments. If you've got more than 50 employees, we'd like you to put on your website of what risk assessments you've done to protect individuals and comply with your duty of care. So I think, as I say, very fact specific. Think about less intrusive ways of obtaining the information. So what is the end point as to why you need temperature versus actually, is it fine that they just come in and they are socially distanced, so actually it shouldn't make too much of a difference. But obviously in some industries you can't do that, such as a care home, so taking a temperature might be more justifiable than in other industries. And from an employer-employee relationship perspective, again, you need to be very careful in terms of agreeing with staff if you are going to take such measures, what you're doing with it, because you've got a risk of breaching what is known as mutual trust and confidence. So you, at the extreme end, you've got an issue of grievances and people resigning over it and claiming constructive dismissal if they feel that you've acted in an unreasonable manner. But equally, we've started getting questions from employers saying, well, what if I ask my employee to have a temperature check or to undertake a test, whatever that may be, and they refuse? What can we do? And again, I think that's quite fact specific in terms of, again, to what end are you asking them to do that? Can you reasonably justify doing that? And if you tick all those boxes, it might fall into a situation where the individual is failing to follow a reasonable management instruction, which could class as a gross misconduct offence. And as I say, at the extreme level, looking at dismissal. But I do think you do need to look at all those different steps as to why, what you've done to communicate, reasonable cooperation, and why you think it's a failure to follow reasonable management instruction. And also look at whether there's other alternatives if someone does refuse. So is it that extreme, or can we look at a first warning with a bit more explanation as to why you're doing it and what the consequences are? Looking at things like unpaid leave for individuals who won't submit to something like that. So I think you've got to investigate all the different options and be able to show that you're acting reasonably in those circumstances. Just going back to your other point, John, as well, in terms of sort of deadlines and meeting SAR requests, one thing that increasingly we're seeing is people making subject access requests because of wanting to bring employment tribunal claims. And one message that I would give is, if your data protection officer is separate from whoever is looking after HR, then just make sure that there's clear communications there, because the last thing you want is for HR still complying with their disclosure obligations and being able to access documents to comply with court deadlines, but then someone else in the other part of the business saying, sorry, because of COVID, we can't access the documents. So again, making sure there's consistencies, but also making sure that you're liaising with HR to see whether there's any upcoming disclosure deadlines, because there's other obligations there as well that you might need to fulfill as an organisation.
Yeah, I think from my perspective, I think obviously there is specific guidance on the ICO in terms of, say for instance, in terms for COVID, but also looking at, from similar to what you were saying, from a proportionate perspective. So obviously it's going to be more, as with anything from a data protection view, it's got to be proportionate. So obviously things are going to be more reasonable with, say, NHS or care providers and to do stuff than maybe other businesses. So I think that's probably one thing to take consideration of. Joanne, I think from your perspective as well, would data protection, would it be effective? Would it be seen maybe more proportionate if temperature checks are being taken but they're not being recorded? Obviously, I think this is something that's probably would come up from doing a DPIA, which I know the ICO suggested DPIA should still be done, and even if they're done quickly and lightly, and you do kind of a short version with the intention of kind of completing it further once you've got all your ducks in a row in relation to COVID. But in terms of those temperature checks and other things, do you think if the temperature check's been taken and it's not been recorded, it's just been taken on the door, does that change the perspective a bit?
I think in terms of, if you're not recording it anywhere, then the question is, have you got any personal data which is stored somewhere, in terms of, you know, if you've just got somebody coming through and they get waved through, I think it's probably going to be hard in most office situations for there to be no recording of a situation, but I do think it all factors into your risk assessment.
Yeah, and I think obviously that goes back to probably some of Padma's points. This was a question that there was a few people have raised in relation to our Q&A. Obviously, go back to some of Padma's points that even if it's not being recorded and you may be more comfortable with it from a data protection side, do you then have an employment issue if people are refusing to have the temperature checked, or some of the points that Padma's raised as well?
Yeah, no, completely. I think it's one of the, as I say, I think it's an area that is evolving, and the ICO is trying to be helpful to give advice. But I think if you are struggling with any of those things, then it as a first sort of port of call, it's always worth having a look at the ICO COVID hub, because they are alive to the fact that there are these issues. Yeah,
and it's something that they have been regularly updating as well throughout this whole process. So moving on to last year's hot topic, but still in the back burner for 2020, the Brexit. So some of you may have joined our Brexit webinar last October. Obviously, as we said then, we're probably reiterating now, nothing is certain, so it's still up in the air. So it is probably likely once we know more information, we'll be doing a further webinar in relation to Brexit later on in the year. But in relation, I know this is something that quite a few of you have asked some questions about in the lead up to this webinar, so it's something that we'll touch now. So at the moment we're in the transition period, so things carry on as normal. GDPR still applies and will still apply in some effect after Brexit. That's something we've been reiterating for the past couple of years, and that's not changed at all. So there's a lot of data flows through the UK. So regardless of the fact that the UK has about 3% of the global GDP, 11.5% according to Tech UK of the global data transfers flow through the UK, and 75% of these are flows with the EU. So obviously there's a hope when discussions pick up a bit more and we've got some more information that following the end of the transition period, there will be some sort of a deal, or there will be an adequacy decision, which I know Joanne will probably mention a bit further. But there is that, at the moment, the position is once we come out of the transition, if there's no deal, what happens then in relation to those data transfers? Joanne, what's the position for all the businesses?
Well, certainly no deal is a potential outcome of this, on the basis, I think if we've not asked for an extension in July, then we're going to head towards a no deal if no agreement can be reached in the meantime. And as we'd sort of discussed before, I think the implications of no deal in December will be the same as there would have been had we ended up with no deal for the transition period. And I think there are three main things that we need to talk about in the context of a no deal. I think the biggest one, and the one that's likely to be most problematic, relates to export of personal data, so export from the UK, and then looking at it in reverse in terms of import into the UK, so export from the EU. The question of whether or not you need a representative is another topic that needs some careful thought, and potentially changes to documentation. So there's quite a few things that need to be thought about. The thing I would say before we sort of have a look at those in a bit more detail, and obviously we don't have a huge amount of time today, and as Lauren said, we did have a webinar where we sort of looked at this, and it took a whole webinar, so I am going to be sort of skating over some of the things, but certainly if this isn't resolved and we're looking to have a no deal, then we'll be looking to put a detailed webinar on which looks at these things in detail later. But the first thing that I think people need to understand, and I still get people saying this to me, is that whether GDPR will continue to apply if we end up with no deal. GDPR will still apply, and also there is this thing called UK GDPR, so that essentially you've got GDPR that applies to the other member states and the rest of the EEA, and then if we crash out without a deal, you'll have UK GDPR. Now, the importance of those two things is that you could be caught by both of them, so that because both of the both GDPR proper, if we call it that, and UK GDPR have got extraterritorial effect. So that with both of them, so with UK GDPR, let's look at that first. If you're established within the UK, or you are selling goods or services to individuals within the UK, or you're monitoring behaviour of somebody in the UK, which can include things like cookies or monitoring via your website, then you'll be caught by UK GDPR. GDPR proper, equally, if you are established in the EU, or you are selling to individuals in the EU, or you are dropping cookies or monitoring behaviour in the EU, you will be caught by GDPR proper. So you can see a situation where a UK business, if they're trading both in the UK with individuals and in the EU with individuals, they will be caught by both pieces of legislation. Now, at the moment, there isn't a lot of, they're not particularly different. So the main things that need to be thought about in terms of if you're caught by both is one, could you end up getting fined under both regimes for the same thing? And that is a logical theoretical possibility at the moment, although I would hope that there could be some cooperation between regulators. So that obviously is a problem. The other thing is in terms of you're going to have a look. Things like your Article 30 register, so where you've recorded what data you're processing, how you're using it, things that will raise an issue, because where you have said that one of the reasons you were processing the personal data is on the basis of compliance with a legal obligation, where you're complying with proper GDPR, that will have to be a member state legal obligation, and where you're complying with UK GDPR will have to be a UK legal obligation, which might seem a bit of an esoteric point, but it's worth bearing in mind that you might need to have a look at your Article 30 to comply with both pieces of legislation. So on the basis that GDPR in one form or another will apply to UK businesses, then I think the question is, where are we left from an export of personal data point of view? So if we look at the easy one first, if you are exporting personal data from the UK to the EEA, the government have said certainly in the short term that will be fine, and you can continue to do that because they understand that obviously you've got the protection given by GDPR and the rest of Europe, so that's fine. If you're exporting from the UK to countries outside Europe, again, it's pretty much business as usual in terms of if, for example, that country's got a finding of adequacy, and Lauren's just mentioned adequacy. What adequacy means is essentially that country has been recognised as providing sufficient or equivalent protection so that you can export data to it without needing to jump through additional hoops. So, for example, the countries where the EU has given adequacy, countries like Andorra or Jersey or Argentina, places like that, New Zealand, you can continue to rely on that adequacy and you can send it there. If you send a lot of data to the States and you regularly use the privacy shield as a method of getting the data to the States, again, provided the US business acknowledges and extends their commitment on personal data to personal data coming from the UK, you can continue to rely on Privacy Shield. So you can still send your data to the US based on Privacy Shield if they give that commitment. So that's the easy part of it. The thing that gets more problematic is if you are a business in the UK and you need data to come onshore from the EEA. So, for example, if you were to have your HR department based in the UK and you've got a subsidiary company based in France and they want to send employee data to you based in the UK, then the question is, can you do that? Now, the problem will be is that if we exit with no deal, when we exit, is that we'll be regarded as a third country, is what they call it. And a third country is essentially someone outside the EEA, and it will be in the same situation as, for example, the US. So that essentially we will have to, in order to be able to take data onshore into the UK, we'll have to show that either we have adequacy or we jump through some other hoops. Now, in terms of adequacy, that is the government's preferred approach. They want adequacy, and that is certainly the subject of negotiation. The difficulty with adequacy is that we don't have a lot of time to get adequacy, and normally it takes years in order for adequacy to be given. And I'm not sure that the EU are minded to expedite that process to help us by December. So if we were to crash out in December without a deal, I think there's a real issue that we won't have adequacy. So if we don't have adequacy, in order for data to come on shore, we're going to have to jump through additional hoops. And the ones that are most commonly relevant to businesses are that you can put in place what are called standard contractual clauses or model clauses, depending on what you want to call them. And that's a contract, well, there are a number of them that have been approved by the EU. So there's a controller 1, controller processor, for example. And if you put that contract in place, then you can export the data. The other one are binding corporate rules, which are rules that exist between group companies. Binding corporate rules are quite tricky because they do take a lot of time to go through and be approved. So if you've not got binding corporate rules by the time we leave in December, I don't think you're going to get those put in place anytime soon. So probably what you're looking at is putting in place standard contractual clauses. There are some other ones and there are some exemptions, for example, getting the consent of each of the individuals affected, but that obviously is very time consuming, and consent under GDPR can always be withdrawn. So I think you're tending to look at standard contractual clauses, which is probably the easiest thing. I think the thing to bear in mind, though, it's not always as simple as people think. And obviously, you've got to identify what contracts you're going to get. You're going to put those in place for that you need them for, where you've got data flows coming onshore from the EU. And also, it will take time to put them in place. Notwithstanding the fact that standard clauses, it will take time to put them in place. So what is euphemistically called a repapering exercise could take quite a long time. So it's not always as simple as people think. The other fly in the ointment with the standard contractual clauses is Max Schrems. Those of you might remember Mr. Schrems from when the privacy shield, the safe harbour was invalidated in terms of transfers to America and became privacy shield. He has turned his attention to the standard contractual clauses, so he doesn't think that they provide enough protection for people, and he's concerned that having a contract in place won't stop, for example, security services from accessing people's data. So that's gone to a national court, which has then gone to the European Court. Now, in terms of where that leaves us, at the moment we don't have a decision from the court. We do have an opinion from the Advocate General, and that's part of this sort of European court process, that essentially the Advocate General gives their opinion first and then it's followed up by a court decision. And what the Advocate General said in relation to Mr. Shrem's argument that standard contractual clauses don't give the protection that they should give and therefore can't be used to export data, is that in their view, they do give protection, they're not invalid, but they've added a bit of a gloss on that, which I think is likely to cause problems for businesses, is that not only must you put the contractual clauses in place, but you also need to think about where the data is going, and are there extraneous issues in terms of in that country that might mean that you should have concerns and you might not want to export the data there. So a level of sort of due diligence that is something that people haven't traditionally done in the context of standard contractual clauses. They also said that they don't really want to comment on Privacy Shield at the moment, but they do have concerns about it. And so when it goes to the court and we get a court decision, it is possible that the court, the court could completely disagree with the Advocate General. They're not bound by the Advocate General's opinion. They could look at standard contractual clauses and Privacy Shield, so we could end up potentially with both of those being invalidated. To be honest, fingers crossed that we don't lose those in terms of how to get data exported, because the impact of the standard contractual clauses going, and also Privacy Shield, particularly the standard contractual clauses, is that if you wanted to export data outside the UK and outside the EU, that's one of the ways in which you might want to do it, in terms of you sending it to a country where they don't have adequacy. But equally, in terms of getting data onshore, if we end up with a no deal from the EU to the UK, that'll be one of the ways that people will be looking to rely on in order to be able to do it. So if it is invalidated, then obviously that will be problematic. I understand that the judgment of the court is due on the 16th of July, so not that long to wait in terms of what the court is saying, but I think past our deadline in which we've got to try and extend our transitional arrangement. But anyway, I'm sure that Mr. Shrem's action won't change the government's view as to whether or not they extend the transitional arrangement. So that's just a sort of a word of warning in relation to standard contractual clauses, in terms of they are currently, unfortunately, under attack. The last thing I was going to, the last couple of things that I was going to say in relation to Brexit is it does raise the question of do you need a representative in the EU? And I think that's one thing that a lot of UK businesses are overlooking. And if you are caught by the GDPR proper's extraterritorial effect, which I was talking about before, so for example, you're selling to customers, individual customers within the EU, so you're caught by it, you will need a representative to be appointed in the EU, unless you can show the personal data that you're processing is occasional, it doesn't involve a lot of special category or criminal offence data, and also that it's unlikely to result in a risk to the individuals concerned. So it is something that people should be thinking about, and there are additional rules in terms of where that representative should be, which, as I say, I don't think we've got time today to go into the real detail on it, but it is something that people should be alive to. And the other thing is potentially updating documentation in terms of looking at things like your privacy notices, having a look at data protection impact assessments. Both of those are meant to consider if there are exports to third countries. So it is something that does need some adjustment, potentially, depending on where you're based, what subsidiaries you've got, what you've said in your notices, etc. So I think the three things, the main three things that need to be thought about if we end up with a no deal is how are you going to get data in from the EU? Do you need a representative, and do you need to update your documentation? So I think probably it's fair to say that if we do leave with no deal, it will need some very careful thought in terms of what businesses need to do, and it's not something that I think you can sort out in a couple of weeks. So you know, don't leave it to middle of November before you decide to do it, if we are looking to crash out without a deal.
Yeah, and what I think I would probably add in terms of what I've seen quite a lot is those kind of contractual clauses. I think people are forgetting that they do need to be tailored in different circumstances, and they're also being pushed quite a lot. If you're appointing a large processor, they seem to be pushed. This is our standard, and they put in generic terms into those annexes, and also not necessarily setting out what they need to do from the data transfers, what countries it's been stored in. So move on to the next slide, just as a quick canter through. So like I said previously, what we were intending to go through in relation to this webinar has changed slightly. So we have got some details in relation to the regulator action. So hopefully that table will be coming up to you now. One of the things people have been asking is there doesn't seem to be that much in the past year. What I would say is that doesn't necessarily mean that things aren't happening in the background. Obviously, British Airways, from their perspective, from the data breach itself, it took an amount of time before before the ICO released the fine. So it may be. Obviously, at the moment we've got the COVID situation. It may be in the next year or so, we see more in relation to fines. But obviously, the ICO does take its time in investigating to make sure that it's being right and the fines it's issuing. Hopefully, we'll stay on that page now.
Sorry, Lauren. Are we back?
Sorry.
Can you hear us now, Lauren?
Yeah, we can hear you now. So we've had the doorstep dispensary, which is that was just a quick one, just to say that was an unauthorised access. That actually was they were fined because there was water damage to a lot of sensitive data. And another one to kind of be aware of is Proximus. So that was in Belgium. Whilst it was only €50,000, it's actually the highest fine that Belgium have issued. And that was in relation to their DPO. Two things that they essentially said was they didn't feel their DPO was sufficiently involved. So one of the things that they did was look at the personal data breach notification form, and there wasn't actually anything in there up until recently which brought in a kind of opinion of the DPO. So one thing to be conscious of is making sure that your DPOs are actually involved and they're not just a tick box exercise at the end. They will need to be involved from a privacy by design type of structure from early on. The second thing that their DPO for Proximus was head of compliance and audit as well. And the thought was that there was a sufficient conflict of interest there, because as part of their role in these kind of other departments, the DPO was in itself determining the purpose and type of processing. So therefore it was essentially marking its own homework. So what I would say is you need to think of it, it's not necessarily that it can't be an audit and compliance, but you need to think about, are you giving enough time to your DPOs to carry out those DPO functions? And strategically, and as type of your organisational structure, are those DPOs actually free of any conflict? Joanne, I don't know if you just got quickly anything to add in relation to the regulatory fines.
No, I mean, not a huge amount. I think one of the things that I was going to say in relation to the regulatory fines is that one of the things that the ICO said in the context of COVID is that they will consider the ability to pay an economic impact in relation to fines, and so fines might be lower. I do wonder, and I don't know whether this will happen, whether obviously you've got an intention to fine issued in relation to British Airways and Marriott, whether the ICO might rethink that, because obviously both of those businesses in terms of hospitality and travel will have been hit really badly by COVID. So I don't know whether that will be the case. I was just going to ask Neil the question, Lawrence.
Yeah, I was going to say, we'll go back to Neil now.
In terms of, from a business point of view, what's your sort of take in relation to Brexit, Neil?
I think you obviously you covered the main things that business needs to be thinking about, but I think the challenge for business is We've already had 2 false starts around no deal and being ready for being outside of the EU in these respects in March and October last year. So many businesses may have already started looking at some of this. I know we did, and we did even during part of our GDPR program to start looking at where we actually had contracts. Not only where we had contracts that were with organisations outside of the EEA, but also looking to see where we had contracts with anyone outside of the UK to start to assess what protections to put in place. Is it privacy shield? Is it model clauses? Obviously, the Shrem's comments that you've made are quite concerning, but I think at the moment that's all that businesses can do with that in mind. I think the other area that our businesses will be looking at, we have operations in the EU, in Lithuania and in Spain, and so that point being made regarding having a different version of the GDPR, an EU GDPR as well as a UK GDPR, is something that we'll have to have detailed consideration of, and that our appropriate teams know which set of rules they are supposed to be following from the end of December. So plenty to keep us busy there.
Thank you, Neil. So in conscious of time, just if we can move to the next slide, one thing that we obviously had initially planned to discuss are other issues that we've been seeing in this past year. So hopefully you'll be able to see some pointers. With us only having 3 minutes left, I don't intend to kind of go through those. But what I would say is that we are looking to hopefully set up some regular webinars, either through presentation or similar to what we've done today from a panelist view. So they're just some kind of types of topics that hopefully we'll be able to get to you in the next few weeks or months to discuss different issues that we're seeing specifically in relation to data protection and GDPR as things are moving forward. Also there's a number of new guidance that's been released in the past year as well. So if you just go on to the next slide, there's some kind of indication of what guidance that we've seen. You'll see there's quite a few that are still in draft, so hopefully that's something that will be finalised soon. I'm hoping that we've addressed the majority of the questions that have come through. We had quite a lot that came through when we were talking about COVID in relation to temperature and kind of employer responsibilities, so hopefully those questions were addressed. If you do have any further questions, then do feel free to contact us after this webinar. There will be an email address coming up on your screen shortly, which is events@owenmitchell.com. So yeah, any further questions, then please let us know. We will be sending around a copy of the webinar where you'll be able to access copies of the slides as well. And like I said, if you need anything further or want a copy of the cybersecurity webinar, then please let us know. So finally from me, we have further information for you on our Owen Mitchell website, and we do have a dedicated coronavirus updates page if there's which hopefully should be helpful for you, or if you want to contact us to ask any further questions. So thank you everyone for taking part. Thank you Joanne, Padma, and thank you Neil for joining us as well. And thank you all of you for joining in today, and have a good afternoon. Thank you.